we are in the absence of the jury, still in open court. Upon the state resting, the court conducted a bench conference with the lawyers. The defendants indicate they have motions to dismiss to be made at the close of state's evidence. The court notes they were made timely, aptly, and duly noted, and I'll be glad to hear the arguments now. But to save the jury the inconvenience of going in and out, the defendant and the state agreed that I could go ahead and understand those motions had been made, and the court had indicated a preliminary indication of ruling on them, and then the defendant rested in the presence of the jury so that the jury did not have to be brought back and forth to take care of that. So now we're hearing matters effective as of the close of the state's evidence.
Thank you, Your Honor. One of the motions I'd like to make, Your Honor, this is a, that's actually the original showcase. This is a motion to dismiss the indictment as effective, Your Honor. Obviously, this case went through a unique and not often used process. That is, a process that began with a presented to the grand jury, Your Honor, if I direct your attention to the file back in December of last year, where the grand jury authorized the district attorney's office to investigate and potentially indict my clients with 4 counts of aiding and abetting the possession and or consumption of alcohol. Subsequently, in January, Your Honor, that's exactly what happened. Each of my clients were indicted on 4 counts of possession, aid and abet, possession and or consumption of alcohol to each of the 4 individuals, Anna Ergish, Thomas Matthews, Jonathan Taylor, and Natalie Freeman. Because North Carolina case law is pretty clear on this issue, we thought it was appropriate to bring this motion now and move to dismiss, because my clients effectively are charged with 8 crimes as opposed to 4. And the way it's pled is 2 crimes in each indictment, aiding and abetting the possession and or consumption of an alcoholic beverage. So what we don't know is exactly what the grand jury indicted them for. Was it aid and abet one or the other, or both? And that's a problem. And that is the basis of the motion. Now, in the alternative, should the court deem that motion not be allowed, I would ask that the state be required to elect one or the other as far as submission to the jury, such that there won't be ambiguity with regards to whatever verdict that they reach. And our position is that that would be the fair and reasonable way to handle the situation should the court deny the motion. Obviously, our second motion is to dismiss on a basis of insufficiency of the evidence. And I won't go into length on that, but just to say that this certainly has the feel of a civil proceeding with regards to negligence. And I understand the state feels very strongly about their accusations, and I'm obviously prepared to argue them to the jury. But I would just note that in my motion to dismiss, even in the light most favorable to the state, we believe that there's an insufficiency of the evidence and that ultimately the charges should be dismissed on that ground as well. Thank you.
Mr. Waller.
Your Honor, the defendants were indicted under the aid and abet theory that is covered in 18B 302C2 because they were both over the age of 21 years of age. That statute does not distinguish between the consume or purchase, that specific statute regarding aid and abet. It just says that it occurs under subsections A, A1, or B, and in this case we would be proceeding under subsection B, purchase, possession, or consumption. We've outlined that the allegations are possession and or consumption in this case. I believe the evidence has shown both that the teenagers were holding wine glasses, therefore possessing it, and certainly the majority of this trial through the witness statements has been about their consumption. The purpose, obviously, of indictments is to put defendants on notice of the charges that they will be facing. This presentment and then indictment tracks the language of the statute in regards to aiding and abetting, and based on it tracking the language of the statute, I would ask that you deny that motion.
So you say it alleges 4 crimes against each defendant, not 8 crimes against each defendant?
That's correct, 4 crimes.
The defendant's motion to dismiss on the motion entitled Motion to Dismiss Defective Indictments is denied. The motion to dismiss based on contentions of insufficiency of the evidence are denied. Did you mention to the defendants that I may confer with them, inquire of them about their decision not to testify in this case?
We have not discussed that, if I'd have a moment, Your Honor.
Will the defendant, Kimberly Matthews, please stand? I'm going with you first since you're in the lower numbered indictment. Your lawyer has indicated you're arresting without offering evidence at this time, which means you will not be testifying at this time. Do you understand you have the right to testify, but you also have the right or privilege not to testify? Do you understand that it is your decision as to whether or not you'll testify? It's not your lawyer's decision. Of course, it's probably prudent to confer with your lawyer in that regard, but do you understand that? Have you made a decision as to whether or not you will testify in this case? What is your decision?
I will not testify.
And whose decision is it?
My decision.
Thank you. You may have a seat. Will the defendant, Charles Joseph Matthews, please stand? A similar inquiry, sir. Do you understand everything that I asked her?
Yes, sir.
And you understand it's your right to testify. It's also your right and privilege not to testify.
Yes, sir.
Do you understand it's your decision, not your lawyer's decision?
I do.
Have you conferred with your lawyer about it? And don't tell me what he said or you said, but have you conferred?
I have.
And have you made a decision as to whether or not you will testify in this case?
Yes, sir.
What is your decision?
I won't testify.
And whose decision is that?
That's my decision.
Right. Thank you, sir. You may have a seat. And the defendant rests as well, and renewed motions to dismiss at the close of all the evidence.
For all the motions previously made, Your Honor.
Those same motions are made and are denied. Are the parties ready for a charge conference?
Yes, sir.
State ready to proceed.
First of all, are there any written requests for instructions from the state?
Your Honor, I have prepared one written instruction, if I may approach, Your Honor.
You may.
One of the footnotes, and I apologize, the proposed jury instruction cites State v. Walden, which is 306 NC 466. If I may approach with a copy of that case as well.
You may.
Your Honor, this case is cited in the footnotes of the aiding and abetting jury instruction, and in that case, State v. Walden, the jury was instructed on the language that I've included in the proposed jury instruction. What I would be asking for in this case is in regards to specifically in the element 2 as how the Matthews aided these teenagers in possessing and consuming this alcohol is the language that I've cited It is the duty of a parent to protect their children and to do whatever may be reasonably necessary for their care and their safety. A parent has a duty to protect their children and cannot stand passively by and refuse to do so when it is reasonably within the power to protect their children. A parent is bound to provide such reasonable care as necessary under the circumstances facing them at a particular time. However, a parent is not required to do the impossible or unreasonable in caring for their children. That case did involve a serious beating of a young child, in which a mother stood by as I believe a boyfriend beat the child and was severely injured. I realize that is not what we have here, Your Honor, but I do believe the language of that case is appropriate in this matter, in which you do have the Matthews essentially standing by while these teenagers are allowed to drink and get to the level of intoxication that we've heard about during the course of this trial. So I think there's case law that would, citing the Walden case, that would support this type of instruction. I understand if the court wants to deny it altogether or make some amendments to that instruction, but I believe what you've seen here is that you have four to five young individuals under the care and custody, allowed to be at their home, at the Matthews home, and nothing was done whatsoever to stop them from getting to the position in which they got. Similar to the Walden case, in which the mother didn't do anything to prevent the severe injuries to the child. I would ask for that instruction at this time, or some form of that.
Tell me your reference to the footnote in the instructions. That
is under the aiding and abetting general instruction, not the one regarding this case. I believe it's footnote 4.
All right. Your response, Mr. Miles?
Well, Your Honor, first and foremost, obviously we object to that instruction, and the case that was passed up to you by the state is a child abuse case. The evidence in this particular case, and of course that's a child abuse, a serious child abuse case. This particular case, Your Honor, we've got 4 18-year-olds and 1 17-year-old. As far as the law goes, they certainly don't qualify as children or minors with regards to the law. And so I don't believe the state can take the position legally that there is a duty to protect or save based on the ages of these particular individuals, that the Matthews had some duty to take action. That is, to some duty that they had to save any of these particular individuals, even though there's evidence, obviously, that they did with regards to Natalie Freeman and with regards to Anna Urgus and with regards to JT as far as being brought back into the house and put in a chair in the library. But Your Honor, I think that is a great stretch and would be a dangerous attempt to create some new law that does not exist if my clients are forced to try to argue that particular instruction to the jury. And I think that the jury instruction as it stands for knowingly aid and abet possession of or consumption of alcohol is the appropriate one to have. There's obviously several different characterizations the state can argue that are appropriate in that jury instruction, and certainly, again, there is no legal history that is relevant to this particular case that gives the state a legal basis. I would argue that this case is just completely different. Thank you, Your Honor.
Thank you, sir. The state's request is made and is denied.
Thank you.
Any further written requests from the state?
Not from the state, no, sir.
Any written requests for instructions from the defendant?
I did make some written requests, but Your Honor, they're all pattern instructions. And I'm happy to present those to you, but if you've already prepared your list, Your Honor, I can just provide those to the clerk, and I expect they're going to be what you've already
All
anticipated.
right, let's go through it then.
Okay.
But to begin with, let me ask the state, if I instruct the jury on possessing and/or consuming, that is, knowingly encouraging and/or aiding an underage person to possess and/or consume, do you have any concerns about unanimity of a verdict if, let's say, 6 jurors thought it was possession, 6 others thought it was consumption? And are you asking that I submit it on both possession and/or consumption? And I'm not requesting or suggesting anything except Mr. Miles made an argument that it could be considered 2 crimes. Aiding and abetting possession is 1 crime, aiding and abetting consumption is another crime. The evidence would certainly support an instruction on both. But I'm just asking you to think about it.
I will maintain my position that this is 4 separate crimes under an aiding and abetting theory for each defendant. Certainly, I believe the case we've proven both, but that consumption is what a majority of this trial has been about, and certainly I would argue too has been proven. If the court is inclined to just proceed on one count there, I would ask for it to be the consumption prong. But again, I think under the statute, with 18, the aid and abet statute, that it covers subsection B, which subsection B includes both possessing and consumption. We've taken out purchase from that because there's clearly no evidence of that.
And this is a statutory aiding and abetting as opposed to being aiding and abetting of some other offense.
Such as robbery, yes, sir.
Yeah, right. In that kind of aiding and abetting, it would make an aider or abetter guilty of that offense. In this case, it makes them guilty of a statutory offense, if they were to be guilty of anything, guilty of a statutory offense of aiding and abetting someone else committing a crime.
Yes, sir.
All right. The court proposed to charge a jury from pattern jury instructions for criminal cases substantially as follows. You all know I do this very informally, so you can keep your seat. Stop me as we go along. You can interrupt me, interject, ask questions, object. 101.05 function of the jury, 101.10 burden of proof and reasonable doubt, 101.15 credibility of witness, 101.20 weight of the evidence. If the defendants request it, or either defendant request it, I'll give it 101.30 effect of defendant's decision not to testify. Do you request that?
Yes, sir.
It'll be applicable to both defendants?
Yes, sir.
Excuse me. Parts of concluding instructions from 101.35, 104.05 circumstantial evidence, 104.20 testimony of interested witness, 'Do either of you request an instruction be given or not be given on photographs and diagrams and so forth as illustrative or substantive evidence? Sometimes lawyers say don't give either. Do you have a thought about it?
Your Honor, I know some of the photographs were introduced under illustrative purposes, and so that I'm fine with that instruction.
Found that, Your Honor.
That all the photographs and diagrams, aerial view, so forth were offered for illustrative and admitted for illustrative purposes?
Yes.
104.20 4.50, those matters as illustrative evidence. 104.94, testimony of expert witness. 105.20, impeachment or corroboration by prior statement. Substantive offense of aiding and abetting an underage person to possess and or consume alcoholic beverages or beverage from 2/7. .272.19, I think the number is. Let me be sure.
And of course, that one, Your Honor, is the one that I wanted to be heard on as far as knowing being added to.
Right. I want to add that to it, but did I give the right number? Is it
Yes, sir.
272.19?
Yes, sir.
Thought that's what I made a note of. And what I propose is one mandate that's applicable to both of the defendants and all of the respective charges, that is 4 counts as to each defendant. And I'll have that in writing. The first element being that a person under the age of 21 possessed and or consumed an alcoholic beverage, to wit wine. I'm not a particular connoisseur, but I understand champagne is wine. So I won't say wine and or champagne. We'll be putting a lot of and ors if we don't watch out. The second element, that the defendant knowingly encouraged and or aided that underage person to possess and or consume that alcoholic beverage. Third, that the defendant knew or had reason to know that the person was under the age of 21 at the time. And fourth, that the defendant was over the age of 21 at the time. And then give a separate mandate for each defendant as to each of the 4 counts, referring to the 4 named alleged underage persons in those indictments. 4 counts as to each defendant. I'll endeavor to have that in writing for you as well before I give it to you, before I give it to the jury. That includes the defendant's request that the word knowingly be inserted into the pattern jury instruction.
Thank you, Your Honor.
Any objections to that proposed charge or request for corrections or additions from the state?
Your Honor, in terms of the interested witness instruction, I think it's probably cuts both ways, because I think some of the witnesses that testified for the state probably have some interest in the Matthews as well. I would ask that you exclude that instruction. I tend to use or ask for the interested witness instruction when there's been some deal or concession made to someone. I guess Sergeant Hoolan's statements of we're not going to pursue any further charges on you could be construed in some way as to that. But I would ask that you consider excluding that instruction, bearing in mind that I think it probably in this case cuts both ways to a certain extent.
Natalie Freeman's testified. Mary Ann, and sometimes referred to as Mary Anna Ergish, has testified. And Mr. and Ms. Taylor have testified. They are the parents of one of the named persons alleged to have been an underage possessor or consumer of alcoholic beverage. So you contend that they are not interested persons?
Certainly the Taylors are interested in the case as for their son, but as to the outcome or towards their bias, I mean, they testified in this case as factual witnesses. Anna and Natalie, based on what Anna to a certain extent from what I saw from the witness stand was as favorable to the Matthews as she was to the state at times. So that's who I have in mind there, and Natalie I thought was pretty down the middle on everything. So I would ask that you exclude it.
What say you, Mr. Miles?
Your Honor, of course, we want it. We think it's perfectly appropriate, especially given that there was evidence that charges got dismissed, but some folks weren't prosecuted. And then, of course, we have evidence that the Taylors have filed a lawsuit against my clients. So given all those circumstances, that I think is what the instruction was designed to address.
State's objection is noted and overruled.
Thanks, sir.
Anything else from the state on the proposed charge?
No, sir, thank you.
Mr. Miles?
No, thank you, Your Honor.
I've got verdict sheets drafted. I'll get the clerk to print them out and have them for you. And I'll be working on the proposed charge on the substantive offense. I'll be giving that in writing to the jury, but I'll give it to you before you argue. You've indicated that you'll be arguing one time, waiving opening argument, Mr. Miles?
That's correct, Your Honor.
And so you'll be arguing one time to begin with, the first argument?
Yes, sir.
And then you'll be closing?
That's correct, Your Honor.
And it sounds like we'll take a break between the arguments. And if you want to stay around here, you're welcome to stay till I get this done for you, but you can go ahead and take a lunch break and get ready. When I get it printed out, I'll put it on your table there. Anything else at this time?
Thank you, Judge.
Anything about arguments we need to address in advance?
I believe so.
I don't have any, I plan to use the PowerPoint for
Carefully,
the overhead projection,
very carefully.
very carefully.
And I'm going to use it as well, Your Honor. I'm not going to put any pictures up there in mine. It's just going to be bullet points.
All right. If there's nothing else, then I'll work here and get this for you. Take a recess until 1 o'clock, Sheriff.
Jury will stand in recess 1 o'clock.
You can leave your machine on.